Good morning all, and welcome to our session today. We have a full house, and we'll be just in a moment here. There we go. All right. Well, welcome to this morning's Richardson Harmon Ober seminar. We're actually, the software is overwhelmed this morning. We have more attendees than the software can handle. So I'm going to owe an apology to the many people who apparently have signed up this morning and are not able to log in. We will make sure that that is absolutely resolved the next time that we present a webinar. We are very appreciative of those of you who are attending, and let me there we go. The topic today, of course, is dealing with rentals in your community. The topic is hopefully of interest to anyone in a commoners development with the great number of rentals that we have. And it's a number that seems to be growing, as we'll talk about in a moment. Just a few quick matters of housekeeping as we proceed. The outline was emailed to all of you this morning at about 9:30. If for any reason you did not receive the outline, an email can be sent to pbaraza@rhopc.com, and it will be sent to you immediately. The prepared portion of this seminar is about 45 minutes. We'll be reserving about 15 minutes at the end for questions and answers. We are very sensitive to your busy schedules, and we appreciate your willingness to devote about an hour to this process today. Please, if you have questions, do not email them to me. I won't be watching my email. The software has the seminar software has a spot for questions. You can type your questions in there, and I'll be responding only to those questions. But let me ask you a question as we begin today. Just have a quick poll. I'm just wanting to find out how many of you have what percentage of rentals in your communities. If you want to go ahead and quickly weigh in, we have over 100 people participating today, so we have a pretty good sample. As you can see, the choices are 50% or greater, all the way down to 0 to 19%. We have more than half of you voting already, and in just a moment, we'll move on. Well, right now, I don't know if you can see the poll results, but it looks like we have about 3/4 of you have now weighed in with regard to your community. About 25% of you have 0 to 19% rentals. Another 25% are in the 20 to 29% category. About 12% of you today participating have rentals in your community that already are 50% or greater. So that's interesting. That tells me a little bit about you. We'll have another poll a little bit later today. Thanks for participating in that. Well, let's move on into the meat of the topic. United States Census data shows that homeownership has been steadily declining since the year 2005. This information, which hopefully is on your screen, let me see if we can get that there for you. I'm showing that you're not able to see that. There we go. The slide is from the United States Census, and you can see that home ownership was advancing until about 2005, from 64% up to about 69.5%. But what we've seen since then is a steady decline in home ownership across the United States until 2014. As you can see, we're down to, once again, about the level we were in 1995. Similarly, in California, statistics have shown that from 2007 to 2009, we had about 57% of homeowners in the state. That number decreased in 2010 through 2012 to about 55%. We're waiting for the data on the next couple of years. Hopefully it's rebounding a little bit as property values and the economy are rebounding. But the point is that non-owner occupiers are a very significant portion of our housing stock. Here's some information from the Federal Reserve Bank of St. Louis. Once again, this is focusing just on California, and you can see again 2005 was the high water mark in California. We had about 60% home ownership, down to the approximate 2013 time frame. We're down to just a little bit over 54%. So the point of that all is that the data is showing that rentals are a very strong part of our economy. Home ownership is just barely a majority of our housing stock. And what does that mean for you, the manager or the association board member? Well, it means that you're going to be dealing with tenants in your community, and it's probably unrealistic to think that it's a factor that's going to go away. So with that, let's talk a little bit about your observation of tenants in your associations. I'm guessing that many folks listening today, this is what comes to mind when you think of widespread renters in your community. Laundry hanging over railings, people letting the building fall apart, people not taking care of the building, and so on. Well, hopefully it's not quite that bad, but that is, I think, the common perception among the association management and governance groups as far as the possible risks of having tenancies get out of control. That may be fair or unfair, but there may be also a big grain of truth in that. Well, let's move on to the big change in the area of common interest developments and rentals in the last really 10, 20 years, and that relates to a case down in the Hemet area. A woman named Isabel Harrison, who had not one lot, not two lots, but she actually owned 22 lots in a senior mobile home common interest development. Apparently there people owned their lots and then they would put mobile homes on them. Well, Ms. Harrison, quite a bit of her life savings and estate was tied up in these 22 lots in a homeowner association called Sierra Dawn. Sierra Dawn Estates amended its CC&Rs and it limited rentals to just 3 per owner. And interestingly, the association did not grandfather in the owners. And so you can imagine the disaster for Ms. Harrison, who all of a sudden had to divest herself of 19 of her 22 lots. Complete disaster for her. Of course, she did what all fine Californians do. She filed a lawsuit, and that lawsuit went all the way up into the Court of Appeals. Unfortunately for her, she lost. But the court battle didn't stop there, because some very active realtor members of the California Association of Realtors took this to the statewide body of the California Association of Realtors and very vigorously argued that this was very wrong and that associations should not cap rentals. That led to 3 different pieces of legislation in the year 2008, in the year 2010, and again a couple of years later, as the California Association of Realtors sponsored bills to try to stop associations from capping or banning rentals. The first 2 bills were vetoed by Governor Schwarzenegger in 2008 and the latter part of 2010. But then we had a new governor, and Governor Jerry Brown. The realtors brought a 3rd attempt, a bill called SB 150, and that bill passed and is now found in the Davis-Sterling Common Interest Development Act as Civil Code Section 4740. Well, let's talk a little bit about what that law does. It's been on the books a few years now, but it still seems a lot of folks are not very familiar with it. Here's the text and the real active part of the statute. An owner of a common interest development is not going to be prohibited from leasing unless that prohibition, and I would include a cap in that, if the prohibition was not in effect when they became an owner. So basically, if your association had a complete ban on rentals, that ban on rentals could affect all of the members of the community so long as it was before January 1, 2012. But associations that amend their documents after the date the statute took effect, in other words, January 1 or later 2012, basically all the members of the community are grandfathered. And important to note that this so-called grandfathering, or this saying that the statute does not apply to you, that applies not just to the people in the association that are currently renting out their home to someone else. It applies to all of the owners, even if they're not renting. So the practical effect of that is that it will take many years for a rental ban or a cap on rentals to have any substantial effect on an association's percentage of rentals in the community, because you're going to have to allow for turnover, because that ban or that rental cap will apply to the new owners as they come on title in the association. Now, the managers that are listening, you can imagine the nightmare of trying to keep track each time a residence, a lot, or a condominium unit changes hands, and now you've got to quickly put that home in, okay, this rental ban or this rental cap applies now to this particular home. The bookkeeping on that would really be quite a neat trick. So associations still can impose an outright ban on rentals. They can impose a cap, in other words, a percentage or a numerical limit on the rentals. It's not illegal, but everybody that's currently in the association is going to be exempted from the application of that until they sell, or unless they voluntarily decide to go ahead and accept it. Now, the moral of the story here, and it doesn't just apply to rental restrictions, but I think anytime an association makes a significant change in something that affects the community, you really need to think about how is it affecting your members. For example, sometimes an association will want to cut back from a 3-pet maximum to 2 pets, and they're aware that a couple of homeowners have 3 pets. Instead of asking that person to decide which of their pets they're going to send away, or worst case scenario, even put down, consider grandfathering. It's not fair of me to speculate, but guess what? I'm going to speculate anyway. Had the Sierra Dawn Association grandfathered Ms. Isabel Harrison and said, this isn't going to apply to you, but we don't want you buying any more, and when you begin to sell your lots, those will be subject to the rental restriction from then on. Would we have had the Sierra Dawn lawsuit that went all the way up to the Court of Appeals? And would we have had Civil Code 4740? I would argue no, we would not have, because this is a classic case of a statute that truly arose from one single situation, but it was an extreme situation. Many people were offended that the senior citizen was being asked to essentially liquidate arguably her whole life savings. Civil Code 4740 does give common interest developments a little bit of help. It's not all bad news. The 4740 subsection D, which is now on your screen, says that the landlord has to provide the association verification of when they acquired title. Okay, well, hopefully most of the associations already know that, but also, more importantly, the name and the contact information of the tenant or the lessee, or that person's representative. So the association is supposed to be notified anytime a new tenant moves in to the property. Now, that's going to come into play a little bit later with one of our very last topics as we talk about these VRBOs and Airbnbs and what have you, Craigslist rentals. But this is something that the association now should be able to find out, is required to be able to be notified by the landlord of who is in the residence, so that you know who to contact in the case of an emergency, you know if there's a problem, who the problem is. All right. Well, let's move along to a related topic in terms of rentals, and that's what is the Fannie Mae, the Federal National Mortgage Administration, I think it's called, and FHA, the Federal Housing Administration. What do they say about rentals? Well, as you probably are well aware, with respect to condominiums at least, the FHA and Fannie Mae adopted project-wide approval guidelines saying that we're not going to loan to any particular condominium in a condominium project unless that whole project meets our lending guidelines. And those guidelines have been slightly amended once. They've been tinkered with a couple of more times, but they're still in effect as of today, January 14, 2015. One of those guidelines is that the association must have 50% minimum owner occupancy. So in other words, you've got to have no more than 50% rentals, or we're not going to approve your project for FHA or Fannie Mae loans. Well, the problem there is that there's another part in their guidelines that says you can't have a restriction on how people sell their homes. So you've got to have 50% owner occupancy, but you can't do anything substantial to force that to happen. So in other words, if you have a rental cap, that could disqualify the rental cap with the purpose of qualifying you for Fannie Mae and FHA loans in your condominium project, could ironically disqualify you from eligibility. At last report, that hasn't been worked out. I don't know that in all the different circumstances that you might deal with in your association, that's the biggest problem that you might face. But the Fannie, there is obviously a contradiction there. Well, how can the associations, how can you reduce or control the number of rentals in your communities? Well, there are a few things that you can do. Interestingly, again, an outright ban on rentals is not something that is against the law in the state of California. There are a couple of cases that hint that this is something that an association could do. If it's going to have an outright ban on rentals, I think that really needs to be in the CC&Rs. Obviously now with 4740, that ban is not going to apply to all of the homeowners, and it's going to apply only to new homeowners. But technically speaking, an association could have an outright ban and just tell owners that they're going to only be able to sell in the future to investor buyers. I'm sorry, to non-investor buyers, to owner-occupiers. So that's an option. I don't know that that's a realistic option, because you can imagine the controversy in your community as homeowners on the one hand say, well, we don't want to have too many rentals, but on the other hand, homeowners are also going to say, yeah, but I want to be able to sell to whoever gives me the best price. And sometimes in a down market, the investor buyer is the more plentiful source of buyers for the homeowners. So rental ban, technically a possibility. I'm not sure it's something you really want to explore. The more common approach, and this is something I first saw about 15 years ago, is associations saying we want to cap the limit of rentals. Now, they're typically in prior days, before the project lending guidelines were in place, associations were trying to limit rentals mainly because of concerns about behavior of tenants, concerns about trying to keep the community more as an owner-occupied, more pride of ownership, what have you. Then, of course, we had issues with people learning that the FHA and Fannie Mae had certain limits themselves. And there were rumbles years ago that limit was 25% rentals. Then it was liberalized, I'm told, to 40% rentals, and of course now it's 50%. Your association still could pass a maximum limit of rentals in the community in terms of a cap, but you could also pass a maximum number of rentals per owner, like Sierra Dawn did. But again, if you're passing a percentage cap of rentals, or you're passing a maximum per owner like Sierra Dawn did, really think seriously about grandfathering the homeowners who are currently going to be in violation of this new use restriction. It's going to save a lot of problems, and I think, frankly, it's more fair so that you don't immediately put one of your homeowners in violation of such a serious issue. So another option is that's a little indirect, is putting a cap on how many residences an owner may own. Some of my association clients already have those in place, saying that you can only own 2 or 3 at most residences, whether they're rentals or whether you're going to have your kids live in them or whatever. That's the most you can do. So that would be another idea of something that you could do. Probably would require an amendment of your CC&Rs. Another one is a waiting period prior to rental. In other words, you have a waiting period of a given period of time, 6 months, 9 months, a year after you close escrow, during which time you are not allowed to rent. Obviously, it's a little bit of investor repellent. They're trying to discourage investor buyers. If the investor buyer really, really wants to rent that and they're willing to wait 6 months or a year, depending upon what your time limit is, well, then I guess they can go ahead and buy anyway. These are These are restrictions. The waiting period is not a prohibition against rentals. It certainly has an indirect impact on rentals. That's the whole point. There is an interesting argument, I think, among some as to whether the 4740 grandfathering applies not only to prohibitions on rentals, but anything regarding rentals. My view is that the statute says what it says. If it's a prohibition, and I think a cap is a prohibition on a certain period of the portion of the community being rented, if it's a prohibition or a ban, I think 4740 applies. But if you're asking, for example, landlords to make sure that they put their lease on file with the management company, I don't think that's a prohibition. I don't think 4740 applies to that. And I think the entire community would be bound by it. So in any event, there may be other things that your associations have or your management company has seen that also are things that tend to reduce the number of rentals in a community. But let's move on. I want to ask a bigger question now. A very good friend, David Brock, who's a PCAM here in Pasadena, really turned me around on this subject a number of years ago. I was happening to attend a seminar that he was doing with his company, and he really made some comments that I thought were pretty profound, because he said, are renters by themselves really bad? Is it this concept of rentals that are bad, or is it how do we get renters to be positive members of the community? Maybe the answer is not just simply viewing renters as per se bad, but maybe the answer is dealing with why are they bad and trying to figure out if the tenants could actually be a positive in the community. As I've thought about that over the last several years, it has come to me that most associations, I don't think, really take any particular measures to communicate regularly with the entire community. They often communicate just with the owners, with their email list or their mailers. The communications go with the assessment bills. Well, I'm just wondering, maybe if boards and managers and lawyers, we could all think a little bit more about trying to make the tenants feel as they are a part of the community as well, that they have a stake in the community. Could they be committee members? Could they receive bulletins about what's going on with the association? Should they receive copies of the association rules? I think they probably should. Not necessarily because they're bound by the rules, because their landlord is typically bound by the rules. But shouldn't they know what's expected of their neighbors and what their neighbors expect of them? So just a thought. As we go through this topic, I felt it would not give the topic justice unless I backed up and asked that bigger question. You may have had, in your own experience, experienced a number of ways in which you have found tenants can be very, very helpful. So let's not always assume that tenants are going to be a horrible problem. Sometimes tenants are a problem, and tenants don't always see the entire picture as they stand in front of the burned out building and are worried about their security deposit. And of course, sometimes our frustration with tenants makes us think, well, maybe the best way is to have somebody like Big Larry to deal with them. However, for the record, we do not at Richardson Harmon Ober condone the use of goons to handle tenant issues. That is not a permanent or legal solution. So let's try some techniques. When a tenant is acting up, obviously the first thing, and sometimes the only option that you have, is to bring the tenant's landlord in for a hearing. The association typically has jurisdiction only over its members, the owners. So you can't typically bring the tenant in for a hearing. Actually, if you take some steps, you may be able to. We'll talk about that in a moment. But oftentimes, if you bring the landlord in for a hearing, they will make darn sure that the tenant is brought under control. I remember about 10 years ago, I was at a board meeting where the board brought in the landlord and the tenant. The tenant was really irritating the neighbors and was doing some crazy things. And the association board explained to the landlord, well, we're really sorry, but we're going to be fining you for the conduct of your tenant because we don't have any contractual relationship with your tenant. And the landlord took the tenant outside, and we could see through the exterior windows, we could see the shadow of the two figures, and the shadow was of the landlord pointing and waving his arm at the tenant. We couldn't hear what he was saying, but his body English told us very much what he was saying. And the tenant was standing there. And about 5 minutes later, they all came back in the room, and the landlord said, "You will have no further problems," and the association didn't. So I know that sometimes boards feel frustrated because, oh, well, we can't bring the tenant in, but remember, you can bring the landlord in for a hearing for the actions of their tenant. You can also bring the tenant into hearing for discipline if, and this is an if, you have already made sure that in your association, tenants are, as a condition of living in your community, they sign a consent that they will not only follow the rules, but that they can be disciplined. But that they can be disciplined by the board as if they were members. Now, that is a very often involves an amendment to the CC&Rs to do it best. But I found that typically landlords really appreciate that because they realize it gives the board an additional option. It gives the board the option of not having to drag the landlord in, but go right to the tenant and say, "Tenant, you've been playing your drums at 2 o'clock in the morning. That's not going to work in our community." Make no mistake, though, the board can still bring in the landlord as well. Sometimes when my clients pass these amendments to their documents, they don't realize you can bring the landlord and the tenant. So that's still certainly an option. As a last resort, of course, there's always the courts. You can take the landlord to court for the continued violations of their tenant, their guest, and depending upon the circumstances, you may be able to bring the tenant into court as well under theories of nuisance or harassment or other tort-type theories, even if you don't have a contractual document with them that they have signed where the tenant has agreed to be bound. So there are a number of things that the association really can do. You know, tenants and owners can present some really interesting situations. I'm reminded as I look at this cartoon of the board meeting I attended in, I think it was Temecula many years ago, where in the front of the room a homeowner was sitting with a chicken on their lap. And the meeting proceeded without interruption. And at the end of the meeting, they put the chicken in the cage and they left. And I asked the manager what the issue was, and they said, "Oh, well, the homeowner had received complaints that their chickens were making too much noise, and the neighbors were alleging that they were a problem, and so they brought the chicken to the board meeting to prove that they were quiet, docile, wonderful neighbors." Well, okay. Let's talk about how we can create a better relationship with tenants and the association, and one of those documents is something that I call a lease addendum. A lease addendum is a document that the association can, by its documents, by your rules or your CC&Rs, require as a condition of renting that the landlord and the tenant sign. The lease addendum can say a variety of things. The lease addendum might be the document where, for example, the homeowner signs a promise that says, "I promise to abide by the association operating rules and regulations, and I agree that if I break those rules, that the association can bring me in for a disciplinary hearing." There are many other things you can do with a lease addendum depending upon the needs of your community. Sometimes an assignment of rents is something. You can require that the tenant and the landlord agree that if the landlord falls behind in their assessments, the tenant promises to go ahead and pay their rent directly to the association till the assessments are caught up. Anyway, that would be a written document. You would need to have it attached to your rules or to your CC&Rs so that homeowners know what's required of them. But it's another significant way that you can bring tenants a little bit more into normalcy in the community. Another situation that comes up from time to time in communities is the landlord who leases out their condominium or their lot in a planned development, and then they want to continue to use the association pools or tennis courts. That is something that is not a good idea. You're obviously overburdening your facilities, and that homeowner is getting double use. When the homeowner leases out the right to live in the residence, whether it's a condominium or a planned development lot, they are giving up the control, the occupancy rights and the things that come with those occupancy rights. And one of those things is the right to use the amenities and the common area recreation facilities. So landlords they should not be allowed to have their cake and eat it too. If they rent out the home, then they should not be able to continue to use the common area facilities as if they were a resident. Check your CC&Rs on this. Your CC&Rs and or your rules can certainly have language in them that makes it clear this is not allowed. This subject was addressed by the California appellate courts in a published decision a number of years ago, and it is a problem that can be fairly easily handled. Landlords and quorum. This is often one of the problems that comes with a very high level of rentals, is that landlords are interested in their rent. Landlords typically want to collect their rent on their investment. They want to be bothered as little as possible, and they, not always, but oftentimes are not involved in the affairs of the association. And that creates problems for you managers and you board members who are trying to have elections, trying to govern yourselves, and yet you perpetually have problems with quorums. A couple of quick suggestions here. What about proxies? Now, I am not a fan of proxies, and people that know me or clients that have worked with me know that I routinely recommend that associations get rid of proxies with one exception, and that is that they keep proxies for purpose of quorum only. So what about having landlords in your community sign proxies solely for purpose of attaining quorum? They're not pre-committing to any decision, but they're allowing the rest of the people who do want to vote the opportunity to make decisions. Now, if your association doesn't want to completely ban proxies, and no, proxies are not illegal, every now and again I'm asked by readers to my newspaper column, well, proxies are illegal, aren't they? No, they are not illegal. If your governing documents allow them, they're not illegal. But I think they're a horrible idea and they're unnecessary these days. But if your association does have proxies where somebody can give to another member the right to vote for them, then you may be able to use that to your advantage. Approach the rental managers or approach the landlords themselves and ask if they would lodge with the association a general proxy that would allow the board of directors to vote that membership how the board saw fit. That would be another way that you may collect some votes where gets the association closer to quorum. Lastly, hopefully your association has governing documents that allow you to have a reduced quorum. And this is another poll that, whoops, have I done this right? Oh, well, okay. You know what? Time doesn't permit. I was going to ask you how many of you have reduced quorums in your associations. Hopefully your bylaws allow you to have a drop-down quorum where if you don't get your original quorum for your election or whatever you're voting on, that you can have a drop-down quorum, typically to 25%, to help you get there and make a decision. I know some of my colleagues in the law profession have said publicly that quorums are a bad idea generally and that your association should eliminate quorums. I really think that's bad advice. I think that's a bad idea. You need some kind of a quorum. You don't want a situation where for whatever reason 10 homeowners could hold a meeting and vote to do anything they wanted because there's no minimum quorum requirement. You want to make sure that a substantial, at least a significant number of homeowners are involved in making membership decisions. A zero quorum does not help you. All right. Can our association limit occupancy? This is a very hot topic right now. Associations have situations where we're dealing with people who are putting 5, 6 people in a bedroom, 3, 4 people in a bedroom. One association contacted me not that long ago. They had a house that had about 15 people in it, and they weren't. This wasn't a family with a lot of children. This was a landlord that was just basically creating kind of his own little slumlord situation. So let's talk for a few minutes about limiting occupancy of residences in your community. One of the interesting things, by the way, about this is that in my research over the years, I have not been able to find typically any kind of maximum housing occupancy standards by most cities. For example, the city of Los Angeles, which you would think has regulations on everything, they have design requirements for how large a bedroom must be, and they have standards for builders to follow. But nowhere could I find in the Los Angeles city or county ordinances any statement that says you can't have a certain number of people live in a single bedroom. So we're kind of on our own right now. And when you're limiting occupancy, you have to be very careful about fair housing law requirements. Because one of the things that the Fair Housing Act is concerned about is what they call familial discrimination. Familial discrimination is discouraging children, discouraging families with children. So the Fair Housing, the California Department of Fair Employment and Housing, which administers the California Fair Housing laws, has followed an unwritten, informal, nowhere documented standard for years of you can have a occupancy limitation of no less than 2 per bedroom plus 1 for the whole residence. So as you can see here from the screen, you can have 1 bedroom with 3 people, 2 bedroom, 5, 3 bedroom, 7, and so on. And as long as you're following that and you're not more strict than that, managers and associations, the rule of thumb is you're going to be okay. The problem with that is, as I show here on the screen, it's nowhere in writing. Now, the topic is white hot right now because for the first time in our state's history, the Fair Employment and Housing Council is in the process of writing regulations for fair housing to explain how associations and landlords can comply with fair housing statutes in our state. One of those regulations is going to be on maximum occupancy. I was actually at the Fair Employment and Housing Council meetings yesterday in Oakland, and this was the largest single topic of discussion, was if the Fair Employment and Housing, the Department of Fair Employment and Housing could have a standard of 2 per bedroom plus 1. The argument by many housing advocates, housing rights advocates, is that actually the minimum should be much more liberal for reasons that really have nothing to do with housing discrimination. So at this moment, and of course these are draft regulations, it's written in pencil, the current proposal is to have the housing limitations that you see on the screen. So in other words, an association could have more liberal occupancy standards, but you can't be more strict than 2 per bedroom plus 1. All right? So stay tuned on that one. My plan is to do a webinar in the month of May on the Fair Housing Act, and hopefully the fair housing regulations will be far enough along by then that we'll have a pretty good idea of what the law is going to look like. All right. Now let's talk about the creative tenant or landlord. One issue that often comes up when we have multiple tenants in the same residence is, Kelly, what is a single-family use? Our CC&Rs say that these homes are single-family homes, and obviously these are not a single family. Well, interestingly, many large cities, such as the city of LA and the city of San Diego, have defined what they mean by single family, and it doesn't mean what maybe you and I would normally think it means. Single family typically means a group of people sharing the same facility. So if they're sharing the bathrooms, they're sharing the kitchen, they're sharing the living room, that may well be considered in your city as, quote, single family usage. So not a whole lot done there as long as we really have the residence being shared. However, what if we're dealing with somebody who's subdividing the unit? The one that I see from time to time, someone will take a condominium bedroom and they'll put up a partition wall. They'll actually put up a framed wall and take one larger bedroom and turn it into 2. Now they can rent out 1 extra room, they think. Well, of course, that's something that your associations should not ignore. We're typically dealing with altering common area. You're dealing with the building and safety department. You may be dealing also with the housing or the planning departments in terms of what the zoning allows. That's really something that you don't want to ignore. Similarly, this phenomenon where a creative landlord or tenant will convert a room. Commonly, you'll convert the living room to a bedroom that was not intended to be a bedroom. A A lot of times your best friend here may not actually be your friendly neighborhood HOA lawyer. Your best friend may wind up being the building and safety department or the housing department in your city. But these are important issues that you really can't ignore. When they're altering the condominium, they're violating the building code potentially. That's something I would first try to get the city involved with, and a lot of times they're going to be able to take care of that for you. But that's a significant concern. A couple of other topics as we come down the home stretch in the prepared part of our time together, and that is dealing with the question of tenants. Can tenants attend board meetings? I actually received an email in advance from one of you yesterday on that very question. And the answer is that tenants do not have a right to attend your board meetings. Tenants are not owners or members. So the Open Meeting Act, which specifically provides for the right of owners or members to attend association meetings, well, this doesn't apply to them. And this position that a lot of us commoners development lawyers have taken for years was finally confirmed in a case called SB Liberty. That was a case decided 2 years ago where, for reasons I still don't understand, a couple of folks decided that they didn't want to go to their meeting themselves. They wanted to have a representative go to the meeting for them, and the court said, no, that's not enough. The member is the one that has the right to go to the meeting. Now, some of you may have rules which don't say whether or not tenants or non-members may attend your meetings. That is a question that you have to decide for your association. Some of you may decide that you want tenants to be able to attend board meetings because you think it's a nice way to include them in your community. Tenants, again, under the Davis-Sterling Act, do not specifically have rights to attend those meetings. They don't have rights to speak in open forum. I'll leave that to all of you. But I think it'd be a good idea to make a conscious decision about that policy and then consider adopting meeting rules to confirm which your position is going to be so that you don't have unpleasant disputes sometime where a tenant demands to attend the meeting and you don't have a solid basis to answer their question. Some associations even allow non-members, in other words tenants, to serve on their board of directors. Now that's an interesting one. Some bylaws do not have any particular requirement for serving on the board. And every so often I see a board where a tenant is elected to the board of directors. Now, this is something that I think really your bylaws, I do have kind of a strong feeling on this. I think that your associations really should require that people be owners, that they be members of the association to serve on the board. If your bylaws don't say so, consider amending your bylaws. I think most of your neighbors are going to feel much better if they know that all the board members are financially invested in the community. I have, over my many years in practice, seen a couple of situations where tenants were excellent directors, but I think in general your bylaws probably serve your community much better by not allowing non-owners to serve as directors. And at the same time, you might want to think about some other requirements as well that are good ideas. So check your bylaws on that one. But again, on this topic, tenants do not have the right to attend your board meetings, and you want to check to see whether your bylaws allow them to serve as directors. Another interesting issue is I'm sorry, let me see if my screen went blank here. I'm sorry about this. Let me see if I can get it back online for you. We're talking now about VRBO and Airbnb and these different services that people use to rent out homes in your community. As I'm hoping that this screen will come back for us here in a minute. Technology, there we go. Interesting article in the San Diego Tribune, a Union Tribune, from October 24, 2014. And this one, this is a quote from that article. If you own a luxurious condo, you might want to make some easy money, but don't let your HOA find out. And then it tells the story of a guy named Thomas Stevens who in July of 2014 had to pay his association more than $106,000 as he lost a Superior Court case that he was renting out his condominium in a very nice location in San Diego on a very short-term basis. And the case was disputed. The gentleman never conceded what he did, but it was a very expensive dispute for him. The issue of dealing with the Craigslist and the Airbnb and so on, that can be a real problem for the association in many ways. I mean, you can think of how many different problems, right? If your project is being used as a hotel, it's not residential usage. Short-term guests, you typically don't have control over them. You have extra wear and tear on facilities as people are continually coming in and out. Imagine the administrative burden on your manager, keeping track of who can use the facilities. And of course, remember 4740 we talked about earlier in this session, where the landlord is supposed to be giving information to the manager about who is actually in the residence. But these are easy to catch. They're advertising. If you want to know if your building is being advertised in VRBO or Airbnb or Craigslist, it's pretty easy to find out because these folks have to advertise to get the short-term tenants they want. Your association hopefully already has rules expressly banning short-term rentals. I personally like to see a minimum one-year term of initial lease term, but your association may have shorter terms. Make sure that your association documents or at least your rules have something about this. And yes, you need to impose fines on this that are significant, but you have to be careful. One of the anomalies in the Davis-Sterling Act is that you can impose fines pursuant to your association fine schedule, but the fines cannot be punitive. They're supposed to deter. Now, I'm not really sure what that means, but it certainly means that you can't have fines that are so large that a judge says, okay, now you're not just poking people, you're really harming them with that fine, and we as a judge may not enforce that. So it's something that associations are going to have to be more and more vigilant, particularly in downtown urban areas or in resort vacation areas. It isn't strictly just the beachfront condos, folks. In the middle of cities, you'll have companies renting out their condominiums as business short-term rentals for 3 or 4 days for business travelers. So it's not just at the beach. So you have plenty of things that you can do about it. Well, that concludes the prepared portion of our seminar. We ran a couple of minutes over on that, but we still have time for questions. I do want to mention our next webinar will be on March 18 at 11:30 a.m. It will again be 45 minutes prepared with 15 minutes for questions. And we'll be dealing with advanced issues in assessments collection. That webinar is going to be designed for managers or treasurers with some basic knowledge of assessment collection. So I want to thank you for attending, and we now have some time for questions. Please do not send your questions by email again. If you look at your screen, you'll have a box for questions, and I would invite you to type your questions on there, and I will go through as many as I can in the time allotted. And let me just freeze the screen there. All right. So we already have a lot of questions. Let me expand that. All right. One question from Carol is, can the association control the amount of tenants that occupy units? And I did talk about that a little bit earlier. As long as you don't go below 2 people per bedroom plus 1, but the issue there isn't just tenants, it's also your owners. So if you're going to have a limit on occupancy, make sure that you don't have less than 2 per bedroom plus 1. Make sure it applies to everybody. Good question, Carol. All right. Yeah, here's a question from Melody. If the owner is contracted a management company, does the association still address issues with the owner? Well, if the landlord has a management company to handle the unit, you're probably going to be better off most of the time dealing with the owner's representative, because that's what their job is, but technically speaking, if for whatever reason the manager, the rental manager isn't doing their job, I don't see anything wrong with going right to the owner and saying, I can't get an answer from your manager, so I need an answer for you. But I think generally speaking, I would try to cooperate with the rental manager. Okay. Let's see. If the owner is this is a question from Cindy. If the owner is using the home as an employee perk, short term, but not receiving income, is this considered a rental? There we get into some gray areas, Cindy, because we have dealt with owners who aren't actively living there. And if the owner is living there and they have a guest room and somebody stays with them as their guest, well, that's a fairly normal situation, whether it's an employee or a family member or whoever. But if the home is vacant and they're using it as an employee vacation spot, then I think we start getting into the issue again of a non-owner occupier, and we get into questions about whether this is really being used as a residence. Cindy, honestly, that's a gray area, and I think that's something that you and your board attorney probably should look at a little more closely. Linda has a question. Would a change in the length of the lease be subject to the restrictions in 4740, the so-called grandfathering statute we talked about that arose from the Sierra Dawn case? And I think the answer is no, Linda. If you're changing the minimum length of a lease, that's not a ban, that's not a prohibition in my book. I think that that's a reasonable regulation that I think would not be subject to Civil Code 4740. One attendee, D, says, can you send us the PowerPoint? This webinar will be recorded and will be saved on the rhopc.com website and hopefully also on my HOA Homefront website. So there'll be two different places where you can find it, and the PowerPoint will, of course, be part of the webinar. All right, let's see. Here's a question from Jonathan. Regarding levying a fine against a non-member if they sign a release, what if the non-member simply refuses to pay a violation fine? I suppose that the recourse at that point would be to fine the member. Well, Jonathan, I think you're partly right. I think certainly you can always hold the owner responsible. Hopefully your CC&Rs say that the owner is responsible for the conduct of their guests, including their tenants. But I think that, and again, this isn't what we want to do, but if the association fines the tenant and the tenant refuses to pay the fine, you could tell the landlord, hey, look, your tenant is refusing to pay the fine. The next step is to fine you, landlord. And the ultimate, of course, and this is really last resort and hopefully rarely ever necessary, technically speaking, the association could sue the tenant, because the tenant, when they sign that consent, that's part of a contract, and the association now does have some contractual relationship to the tenant by virtue of that consent. So I think you have a lot of options there, but I agree with you, Jonathan. I think I'd start with the landlord, because the landlord has the most leverage of all. That's the ultimate leverage of eviction if people don't behave. Let's see. Question from Lance. Can a board voluntarily have the association vote to cap rentals without grandfathering in the homeowners who have not yet rented out their unit at the time of the vote? The answer, Lance, is no. 4740 grandfathers everybody in the association, not just the people who are currently renting. So if, Lance, right now you're an owner-occupier and your association adopts a cap on rentals of, say, 40%, then that cap is not going to apply to you. 3 years from now, if you decide to rent your unit, you can. Civil Code 4740 protects you. The only exception to that would be if you, for whatever reason, voluntarily said to the association, okay, I'll waive my grandfathering. And, of course, why would you do that, right? All right. Hubert has a question. Why not talk about 2 plus 1 per bedroom and not 3? Or I'm sorry, why talk about 2 per bedroom plus 1 and just not 3? The idea behind that, Hubert, is that we're trying to protect a typical couple that might have a child share the bedroom with them when the child is small. So that's why they talk about 2 per bedroom plus 1. So the idea is there might be a small child living in one of the bedrooms. Now, again, this is so far it's been the generally accepted interpretation of the fair housing laws in our state, and hopefully that will become the final regulation. But that's the idea behind it. Okay, let's see, we've got a few more minutes. I thank all of you for your many, many questions. I'm not going to be able to get to all of them. I'm trying to pick through and get a nice representation for all of you. Our community, okay, Kat, here's a question. Well, some of your questions I think are pretty technical, and okay. Here's a great question, Kim, that applies to, I think, many of you. Do we have to actually amend the CC&Rs to put in a rental cap, or can the board just vote on it? Well, the best thing with a use restrictions really should be in the CC&Rs. That's the best thing. That way everybody gets notice of it. I think there's the association could theoretically have the board adopt a rental cap by operating rule, but remember, operating rules can be changed anytime the board wants. So that's something that could be eliminated as soon as it was passed. I really think use restrictions should be in the CC&Rs, and if it's going to be in the CC&Rs, Kim, yeah, the whole membership has to vote on it. And by the way, associations, if you've got an association that's already at about 45 to 50%, don't bother trying to have an association vote on your cap. You've got way too many landlords. You're going to have too much controversy. You're not going to get enough votes. You'll be wasting your time. I've had some associations try to grandfather, even before the statute took place, try to grandfather all rentals, but the sheer number of rentals in the community would cause owner-occupiers to say, yeah, but I want to be able to rent in my community if I want to, and this might stop me. So there is a point to where your association maybe should look at a one-year waiting period or something like that instead of putting a cap if you're already way up there in terms of numbers. Let's see. I've got just another moment or two. Here's a great question from Jeff, and this actually was one of the issues addressed in the similar to the issues addressed in the SB Liberty case. In the case of a trust, does just the trustee have the right to attend the board meeting, or all of the individuals listed as part of the trust? That's similar to a power of attorney question. In the case of a trust, the individuals that are listed as part of the trust are normally considered beneficiaries. The trustee is the representative of the trust. Same thing with a power of attorney. If somebody gives away their right to vote for their unit with a general power of attorney, then that person doesn't have the right to speak anymore. They have given away their membership, well, they have essentially loaned their membership rights to somebody else. So the trustee or the power of attorney holder, they would be the people that would attend the board meeting or vote on behalf of that unit or that lot, and they would be the person that would receive the notices. All right? Very good question, Jeff. That gets a little technical, but it does come up more and more with folks with living trusts. Well, all right. Well, I very much appreciate you participating. We had an amazing turnout today. I very much apologize for the couple of times we had the screen freeze. Wish I understood why that happened. If your question was not answered, I can't promise to answer every single one by email because we literally have about 50 questions here submitted today. But I also, of course, would welcome you to submit your questions to HOA Homefront, and I try to answer 2 questions every week in my column there. So thank you very much for attending. This webinar will be saved in a day or 2 on our website for folks that were not able to participate today or maybe want to see parts of it or listen to parts of it again. Thanks very much, and with that, I'll say goodbye and wish you all a very good day.